you know, Kenji, si Hinobaten, and sige, let's give it to Mildred Montes. Ito to, si Kenji, si Montes, Hinobaten, and then si Kenji si Paris. For a while lahat na ako, kita ko na ko yung ano.
Attorney, mag-pick na lang muna ako for the attendance.
Okay.
Okay na po. Thank you.
Okay. So si Kenji, si Pete, and si gusto to isa, si Mildred. Okay. Si Mildred.
Yes, attorney po.
Okay. So let's discuss the cases of Central Bank of the Philippines, Sikam versus Jorge, and Meralco versus Ramoy. Is that okay with you? No, I believe nabasahan na niyo, no? That is the first 3 cases, man. So, nakabasa mo na. Okay. Sige, si Kenji. Kenji?
Hello, good evening, attorney. Good evening, President.
Okay, I'll tell you when to start, okay? I'll just ask you questions. Okay? So, in the case of Central Bank of the Philippines and City Trust Banking Corporation, tell us about the parties in the case. About the parties lang, not about the, about the parties.
Yes po, attorney.
Part of the relationship, etc.
In the case of Central Bank of the Philippines versus City Trust Banking Corporation, here the petitioner is the Central Bank of the Philippines and the respondent was the City Trust Bank.
Sige. What is who is the client here and who is the respondent bank here?
The client here was the City Trust Bank and the Central Bank of the Philippines was the debtor.
The debtor. Why do you say it's the debtor, Kenji?
City Trust Bank and the debtor because
You just mentioned it's Central Bank, which is the debtor. Is there a debtor-creditor relationship in this instant case, Kenji?
Yes, sir. Yes, sir. Because the City Trust Bank is the depositor.
And it is considered what?
It is considered as a debtor-creditor relationship.
Which among the two was the creditor? Which was the debtor? Was it Central Bank or?
The Central Bank was the creditor, attorney. Sila ang may utang. Kasi ang City Trust Bank is the depositor man. So sila ang debtor.
Do you agree? Sige daw, let's isugdan mo na na. Pete, again no button. Do you agree? Pete, are you a repeater, Pete?
From others, here in the St. Thomas po, first time po.
Okay.
Pero
Sige.
I took,
Do you agree in a deposit contract of deposit, the nature of the relationship, actually you're correct, no, Kenji? The nature of the relationship between the bank and the depositor is that of creditor and debtor. Pero do you agree with Kenji, Pete, that the debtor is the depositor?
yes, no attorney.
What do you mean by that? Who is the
Because
in the relationship? Who is considered the debtor, or which among between the bank and the depositor, which is considered the creditor.
The creditor is the depositor, while the debtor is
Debtor,
the debtor is the bank attorney.
the
Oh.
depositor bank.
Yes po.
Okay. So, okay, Kenji, no? Ang bangko, the depository bank is the debtor. The depositor is actually, the relationship therefore in a contract of deposit, depositing bank, is that of a creditor and debtor. Creditor being the depositor and the depository bank being the debtor. Remember that, ha? Okay. In this case, what was, sige, Kenji, how about, sige, next, si Mildred. Mildred.
Yes, Attorney.
What happened in the case? Who filed the case first against?
Again, I may ask again, Attorney, what's the question? Who filed?
What happened in this case? Who filed the case against whom?
The City Trust Attorney.
What happened? Unsa din nahitabo?
It's because the City Trust been paying a demand deposit account at the central bank, and then the City Trust actually provided those signatures to the City Trust Banking Corporation. However, what happened is that there's this name Flores who cashed two checks payable to City Trust bearing those signatures of authorized signatories. However, what happened is that he signed a fictitious name when receiving the funds, and that detail was unnoticed by the bank's teller before processing. So it seemed that those checks or those money that was received by Flores was stolen, Attorney, and the City Trust was asking for a to refund or to return.
What happened to the check in this case? Why was it that City Trust was questioning the encashment of the check name of that person who signed Rosauro Kayabuyab?
Was an attorney. The BSB's teller
No.
wasn't able to
What-
verify.
What was the allegation of City Trust?
A negligence, Attorney.
The allegation of City Trust, what is the reason why ningon siya na he is not, or it is not liable for the kanang wrongful encashment? What do you think is the reason why City Trust is asking for the refund of the money withdrawn by an impostor?
It's because the bank itself is liable for the negligence. Attorney is responsible.
Kenji, what was the contention of City Trust?
The City Trust alleged that the check were already cancelled because they were stolen. So that they demanded for the restore the amount.
Sige. So,
Attorney.
City Trust contended na it could not have issued the check, the said check, because, or if indeed it issued the said check, those checks were already stolen, and those were already cancelled. So therefore, any withdrawal or any encashment out of that out of those stolen checks, no, they were not valid, no, they were invalid. And how did the Supreme Court, Pete John, rule on this case?
Attorney, the decision was ruled that both bank were liable and that 60-40 should be equally reimbursed doon sa loss na funds, attorney.
Okay. Who is most negligent? Who is most guilty in this case?
In this case po, attorney, City Trust, because
Okay. Sige, City
because
Trust.
according to the City Trust, because according to the facts, attorney, they were
So,
they allowed they allowed Flores to steal checks and failing to timely cancel the checks, attorney. Then failing to explain the circumstances surrounding the supposed theft and cancellation of the check.
So it was, you're saying that it was City Trust who is the most guilty in this case, so therefore should bear the 60% of the damage of the amount?
Yes, attorney.
Sige, do you agree, Mildred?
Yes, attorney.
How about you, Kenji?
No, attorney.
Sige, why do you say no?
Because the court deems it proper to allocate the loss between petitioner and City Trust on a 60-40 ratio, then the petitioner bank or central bank was more negligent than the City Trust.
Okay, sige, you're correct, no, Kenji. What were the indicia, no, of negligence, no, on the part of the central bank? What are those?
On the part of the central bank, their negligent was the senior teller and in the presence of Illuminada did not verify the signature of Rancibal Flores upon the encashment of the cash deposit slip, wherein in the cash deposit slip it should be affixed the signature of the kisa to nga kuan ni pangalan signature pintaw sa signature ni Rosario, it must be the affixed signature of Rosario Kayabyab, attorney.
Sige,
That's right.
Okay, thank you, Kenji. What is the degree of diligence required for banks? Therefore,
The degree of the bank shows the as the fiduciary nature, shows the diligence of a good of a family.
sige, do you agree,
Is it
Mildred?
practice?
Thank you, Kenji. Do you agree, Mildred, that banks should, because of the fiduciary nature of the bank transaction, they should exercise the diligence of a good father of a family? Mildred.
Yes, attorney.
Pete, do you
Also,
agree?
Yes, attorney. Under Article 117, 1173,
All wrong.
72.
Okay, you're all wrong. Sige. Banks, they are obliged, no, to observe the highest standards of integrity and performance, not merely the diligence of a good father of a family. No, in fact, almost in all cases, no, when the bank allows the encashment of a check, of a forged check, even if the check appears to be genuine, the bank is still liable because, said the court in most of the cases, the banks ought to know the signature of each of its clients. No, imagine the burden for the bank. So munang dapat moagi siya clearing, no? Ang cheque, no? Before it is or clearing and then verification sa ilang mga officers in the bank. So not merely the diligence of a good father of a family, but the highest standards of integrity and performance. You would question, is that the same with extraordinary diligence? I would say that they're different, no, because specifically the Central Bank Act of the Philippines specifically provided for this degree of diligence. So, the highest standards of integrity and performance. Okay, so were it not for the negligence of the bank, also the City Trust was also negligent, correct, Kenji?
Yes, attorney.
How was it negligent? Or why was
On the
it?
part of the City Trust,
Yes.
on the part of City Trust, the City Trust was failed to timely examine its account, failure to report the cancelled checks and notify the petitioner of the alleged loss theft because niagi pa siya og 1 year and 9 months bago nila report ang check it was stolen.
Sige.
Attorney.
Sige, thank you. That is the Central Bank of the Philippines versus City Trust. Sige, how about the case of Sikam versus Jorge? Okay, let's ask Sir Pete. Okay, nag-volunteer man ako for the 3 cases. So, who are the parties to this case? Now, don't tell me nga, Sikam is the petitioner, Jorge is the respondent. Tell me about their relationship, what is the...
So, SICAM in this case, so the parties to this case is Roberto C. SICAM and the agent siya, DRC SICAM Incorporation against Lulu V. Jorge and Cesar Jorge. So, in this case,
nature of their relationship, Pete.
so Lulu Jorge found several pieces of jewelry to
On, on,
pawn po, attorney.
okay.
Pawned pieces of jewelry to Roberto Sicam and the agency po.
Okay. So, there was, what was the, their contract, therefore? So, it was unsa man na siya?
Si Jorge is the creditor while the Sicam is the creditor po, attorney. Oh, no. But opposite po, attorney. Sorry.
It is a pledge, no? Contract of pledge, no? I-pledge ni Gipon ni Jorge, Lulu Jorge, ang yahang pieces of jewelry to the... What was, in such a case, it's actually an accessory contract of pledge. The original contract, the principal contract is loan. No? Nag-loan si Jorge from the bank, from Sicam, Henja. Tapos, ayan, himong collateral ng yahang pieces of jewelry. So, what happened in this case? Mildred.
So,
Mildred.
Yes, attorney. In the case of Saicam versus Jorge,
Sige.
Saicam versus Jorge. So, in this case, Lulu pawned jewelry with the petition.
Question, Mildred, what happened to the pawned jewelry of pieces of jewelry of of Jorge and
So, two armed men robbed the pawn shop attorney, taking the jewelry attorney.
there was a robbery. So there was a robbery in this case. So why was it that the pieces of jewelry were stolen? Okay, and therefore Jorge, what happened? Why is he claims or she is claiming the return of the jewelry or the value of the jewelry from the pawn shop? No? What was the defense of the pawn shop and SICAM in this case? Milde. What was the contention of SICAM? No? Okay, so okay, return the jewelry or pay me the value of the jewelry. SICAM said no. What was the reason of SICAM? What was the justification of SICAM?
He contends attorney that he is not the real party in interest, as he said that the pawn shop was incorporated
That is what
as Ahen Shadi. I'm not sure how to pronounce attorney SICAM.
SICAM is okay. No, that is one contention, but how do you relate that to our present case? Or ano? About negligence. Now, kanang inato nga contention or contention properly pertains to ano man na siya, corporation law, no? The corporation or a juridical person, they have different and separate personality from its owner. So yan na siya. But how about negligence? What was the defense of SICAM against the claim of Jorge?
Attorney, the case of the case of the robbery was unforeseen and unavoidable.
So it mentioned this, according to one, it's a for 227. Now according to the bank, it was not negligent now for the loss. Is that correct, Mildred?
No, attorney.
It is. What was
Ay,
the content?
ano nga yung question, attorney?
Therefore, the bank is saying that it was not negligent in this case. It should not be blamed for the loss of the jewelry because it was lost due to circumstances beyond the control of it. Diba? That's the contention of the bank of SICAM. Correct?
Wrong, no, attorney.
What was the contention of SICAM? To escape liability.
The contention of SICAM was actually that such robbery was again unforeseen and avoidable. However, it actually does not inherently absolve him of liability because according to Article 1173, it sets the standard for fault or negligence based on the diligent care aligned with the nature of the obligation in the specific circumstances of attorney.
So how was another question, was SICAM negligent in this case?
Yes, attorney.
Kenji, how was SICAM negligent in this case?
Yes, attorney, SICAM was negligent on the case because the robbery was punishable, attorney. It is not a fortuitous event. Does not constitute a fortuitous event ang robbery.
And why was it not considered? Do you agree? Robbery is not a fortuitous event. Do you always consider robbery in the course of your business, Kenji? Now, do you always consider the possibility of robbery in the course, in the ordinary course of business? Therefore, no?
Yes,
Wala
attorney.
wala na lang inana na business, no? If kuan. So, but in this case, the court discussed, you can appreciate, no, how circumstances vary. No, as we mentioned, no, negligence is actually a relative concept. No, diba, there was comparison to cases like, kung sa to mga cases mentioned here, for a while. Okay, there was cases mentioned like, okay, for a while. Lang okay, katong Austria versus Court of Appeals, Hernandez versus Chairman of the Commission on Audit, and Cruz versus Galan, no? The court compared those cases to the case at hand, no, in the case at bar, no. Diba, they were all cases of robbery, no, but said the court, they were those say banks or pawn shop, they were excused in those instances. Or even this one, katong employee of the there was an employee in such a case, no, there were robberies, no, but in those instances, no, the defendant were absolved from liability. Now, why is it here na it was the defendant was held liable even if the loss was due to robbery? So therefore, robbery per se, doesn't mean that it's always caso fortuito, correct? No, there are elements for, but that is the next topic pa, no? Talking about negligence pa, Dere, okay? So, you have to establish the negligence of SICAM. Said the court, SICAM was negligent. And how was it negligent in this case, Pete?
So he was negligent because according to the case attorney, the vault was left open at that time of the robbery, and that there was no security measure adopted in the operation of the pawn shop vault.
Oh, sige. So, kindly take note ha, read the case in its entirety, no? So you'll appreciate, no, how the court ruled in those cases, past jurisprudence, no, when it said that the robbery absolved the defendants from liability, unlike this case of Sikam versus Jorge. Sige, the next case, Meralco versus Ramoy. Okay, Mildred, what was the nature of the relationship between Meralco and Ramoy in this case?
Attorney, the national pa- ay, ano? The National Power Corporation filed an
Sige,
filed
sige, what is the relationship of Meralco and Ramoy here?
Okay, attorney, the National Power Corporation actually filed an ejectment case against
Mildred, unsa may relasyon nila Meralco Ramoy in this case? How are they connected?
I'm sorry, attorney, I'm not sure po.
Okay, Kenji,
Yes po, attorney.
how are they connected or what is the nature of their relationship? Si Meralco and Ramoy.
Obligor and obligee, attorney.
Sige, ang sa may ilahang kanang connection. Parang kuhan man sila, no? Nag-abot man sila sa korte. Kenji. Sige daw, Pete.
So, in the case po kay Ramoy and other respondents in this case were illegally occupying the properties of Manila Electric Manila Electric Company, and they filed a case
So,
against the
Meralco was the, so, so they got Pete. Kasi gawas.
yes po, attorney.
Isa Manila, is a service provider, Meralco. Tapos customer ni, ano, Ramoy, is that correct?
Yes.
Like, what happened here? Sige daw, Mildred, what happened? Why did the Ramoy file the case against Meralco?
Attorney Ramoy actually availed electric service po sa Meralco. However, there is this dispute. The NPC again they filed an ejectment case against Ramoy and other several individuals for allegedly occupying property illegally. And with that ejectment case, the court initially ruled in favor of the National Power Corporation. So after that ruling, attorney, the National Power Corporation requested the Meralco to disconnect the electricity supply to the properties involved, including those of Ramoy and the other individuals. So without verifying first, Meralco complied with the request of the NPC without again first verifying the finality of the court ruling. So after the disconnection, attorney, the respondents claimed that they were actually outside of the NPC's property limits and they sought for the damages from Meralco for the wrongful disconnection, attorney.
Kenji, what was the cause of action of the respondents of Ramoy against Meralco? What was the basis of the liability of Meralco to Ramoy? When a file of respondent to the Meralco, on what ground? What was the cause of action?
Meralco was failed to exercise his utmost degree of care and diligence required, attorney.
So what was that?
In that
Was it,
case,
sige, unsa man, negligence. What kind of negligence was present in this case? Was it culpa apeliana, culpa criminal, or culpa contractual?
it's contractual, attorney.
So why was it culpa contractual? Was there? You applied that to the case. Why? What do you think is the reason? Anong culpa contractual man? No? Why not culpa apeliana? Culpa criminal? Was there a contract between Meralco and Ramoy? Sige. Pete, na may contract si Meralco and Ramoy. What is that cause of action?
Yes, attorney, they have a contract because under a service contract whereby they are Meralco is obliged to supply the respondents in this case with electricity, attorney.
Okay, was the cause of action proper.
In this case, attorney, yes, the cause of action was discord.
Thank you, three of you. No? Let's proceed to the next topic. So there was actually negligence on the part of Meralco in discharging their in the discharge of their contractual obligation towards their consumers, specifically the Ramoy. The Ramoys in this case, it is Meralco was obligated to provide uninterrupted and continuous supply of electricity without any validation at all. If indeed the household of the Ramoys were included or part of that case where the court ruled na they are illegally occupying the property. Sige. 1174, this is the enunciates the principle of fortuitous event, caso fortuito of force majeure. As a general rule, you are not liable for the loss of the thing. Take note of that, especially if the loss is due to a fortuitous event or a caso fortuito. Now, unless of course when the stipulation of the party or when the nature of the obligation requires assumption of risk, those are the only instances where you are liable for the loss of the thing, even if it's lost due to fortuitous event. Other than that, no, you are not liable. You have to the elements, or the characteristics of a fortuitous event. Now, the cause must be independent of the will of the debtor. There must be impossibility of foreseeing the event or of avoiding it, even if it can be foreseen. And the occurrence of the event must be of such a character as to render it impossible for the debtor to perform his obligation in a normal manner. So take note, caso fortuitos, you are not liable. Robbery, etc., storm, earthquake, other calamities, etc. If that happens, terrorism, or war, caso fortuito, you are not liable. That's a general rule. But you will learn in the cases that is all not. There are a lot of exceptions, even if there was a typhoon, even if there was robbery, such as in the case of Sikam versus Jorge, still said the court in such a case said the court that is not caso fortuito. Okay, so let's discuss the case of Philippine Airline versus CA and Zapatos, Southeastern College versus CA, Philcom Satellite versus Globe, Phil Estate Properties Incorporated versus Go. So I need pinaman na kaso 1, 2, 3, 4. 4 cases. Sige, nanay upat sa kuha nga tabangan na mo na ni. Si Ismael, si Redondo, for a while Villanueva, o Bagnaan. Takon sa lakon yung Redondo, Ismael, Bagnaan, Redondo, Ismael, and then si Villanueva. Nag-submit ka, sir, no? Yung next card.
Yes, sir.
Sige, ganun pa tayo. Okay. 4 cases. Sige, let's discuss the cases, no? Sige, Pal versus Court of Appeals and Pedro Zapatos. Sige, again. O, tanda mo, what is the nature or what is the relationship of Pal and Zapatos in this case? Okay, Francis, Joshua.
Yes, attorney, good evening. So in Philippine Airlines versus Pedro Zapatos, this case involves Pedro Zapatos as a passenger of Philippine Airlines Flight 477 bound to Cotabato City and I bound to Osami City rather, and they will have a stopover in Cotabato City, Bulacan.
Bound for Samis, no?
Yes, attorney.
Sige. So, what was that contract of the parties? The contract of carriage, no? It was a contract of carriage in this case. Sige. So, what triggered this case, Christopher Villanueva? Why did Zapatos file the case against the PALs?
Zapatos filed a case against PAL attorney because there was a delay. However, PAL did not accommodate him very well. That's why he filed a case for not giving due diligence to give comfort and safeguarding the convenience and safety of its passenger.
Okay. Francie, Magnan. So what was the defense of PAL?
The defense of PAL attorney is, according to PAL, they are not liable for those events because those happenings are due for a fortuitous event attorney, or the PAL claim that it should not be charged with the task of locking the passengers for their comfort because the flight was due to a fortuitous event attorney that if made liable and the burden is given to PAL which over and beyond its duties under the contract of carriage for attorney.
So there was it was not liable, for the delay in the flight, no, correct? Francie, si Ma'am Ani, what was the ruling of the Supreme Court? What was the reason why? What was the reason of the delay, Ma'am Ani? Redondo.
The reason of the delay, good evening po, attorney. The reason of the delay po is due to the heavy rains po, attorney.
So did the plane take off as scheduled? So in this case, ato Ma'am Ani.
While on flight, about 15 minutes before landing, the pilot received a radio regarding the weather condition po. So upon arrival at the Cotabato City,
No?
yes po.
Okay, sige. So, pero 15 minutes before landing to the destination, something happened, something occurred. Sige. So, okay, what happened after, Ma'am?
So PAL informed the passengers of their options to return to Cebu or to return to Cebu on flight 560 on the same day and to Osamis on August 4, 1976, or to take flight on Cebu on and arrive on at Osamis at 5. So from flight 560, there are only 6 seats left and the priority is based on check-in sequence po. And si Zapatos po attorney, as he was a passenger number 9, so he was not given a priority po attorney.
So instead of going to Cebu, what happened?
And instead of going to Cebu, the plane landed at Cotabato City. Then Zapatos was he did not given priority. He was left in that area wherein there are conflicts between the government and the Muslims in that country po attorney. So the passenger was not given a proper kumbaga hindi siya natagaan og kanang kumbaga, wala niya ang right ni abot ang destination po. So
Sige.
SPAG did not consider the situation po, attorney.
Sige, thank you. Ma'am, Sir Joshua Ismael. Sige.
Yes, attorney.
The storm considered for 2207 in this case.
Yes, attorney.
So therefore, if
Therefore,
PAL is not liable, correct?
yes, attorney.
And do you agree?
It is a fortuitous event, attorney, but
Diba? Sir Chris, do you agree that storm that caused the delay was a fortuitous event, therefore PAL is not liable to Zapatos? Christopher, Sir Christopher.
Ay, sorry, attorney. PAL is not liable. PAL is liable, attorney.
So therefore, to my question, the answer to my question katong is the storm considered fortuitous event.
Yes, attorney. However, PAL has the duty or has a duty to
Or a better question, can PAL invoke fortuitous event to escape liability? Sige.
No, attorney. He cannot invoke that defense, attorney.
And why is that?
Because in common carriers, attorney, they are required utmost diligence to carry their passengers safely. And also, if there were fortuitous events which were in fact expected to be to them as the airplane companies, they have the what we call that the safety measures, or in order to give the comfort of their passengers, attorney. So they are expected under the court. They are expected to give them the best accommodation in favor to their passengers.
Okay, no, yeah, said the court in this case, if the cause of the non-fulfillment of the contract is due to a fortuitous event, it has to be the sole and only cause. Okay, but what happened in this case is that the negligence of PAL, considering all the circumstances of the case, the negligence of PAL actually aggravated the suffering or the injury of its passengers. The cause of the non-fulfillment was not solely and exclusively due to fortuitous event, because the airline could have done something to prevent the injury suffered by the passengers. Okay, so therefore, it was although it may be caso fortuito, but the airlines, PAL cannot properly invoke that principle, because there was negligence on its part, which contributed to the injury suffered, or the inconvenience suffered by the passengers. So how about the case of Southeastern College versus Court of Appeals and Dimaano? Okay, Ma'am Francie. Sige, what happened in this case? How did who filed a case against whom in this case?
So in this case of Southeastern College, attorney, so there is a powerful typhoon Saling that happens, that there is destroying the portions of roofing in the private Ida school, in the rip off and blown away and destroying portions of the roofing of private house which landed into the house of Dimaano. So that's why respondent alleged that the damage to their houses was uninhabitable, forcing to stay temporarily in their house and 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 I so it happens there that there is a typhoon Saling and there is a damage of the roof of the building of the private respondents, Dimaano et al., resulting from the impact of the falling portions of the school buildings, roof rip off by the strong winds of the typhoon Saling. And they file a the legal compensation due and
Compensation? Was there legal compensation in this?
I know attorney and they file for damages for the for the damages of it attorney.
Sige. What happened?
And accordingly attorney in this case attorney the Typhoon Saling there is no question that the Typhoon Saling is a fortuitous event attorney and a natural occurrence, but also attorney it is foreseen but it is unavoidable, and despite of any amount of foresight or diligence of care to exempt from the criminal liability arising. So
Francis, was the crime committed in this case?
attorney,
Was there a crime? You mentioned criminal liability. Was there a crime committed?
no attorney.
Asa man to nimo gikan nakuha tong crime? Or say, what did ChatGPT tell you about the case?
No attorney, I'm reading the full text attorney for baan ko attorney.
Why did you mention criminal liability na diha sa case?
No attorney pag na nako sa attorney.
Oh.
So asa na gaito dapat attorney?
So simply the school there was a storm, the trip
Yes po attorney. Yes po.
school, and unfortunately it landed on the house of the private respondents.
Yes po attorney.
Were there injured persons?
No po attorney.
Okay, so there was no liability. Now, was the school negligent in this case? Or can it properly invoke fortuitous event? Francie?
Yes po attorney. It is purely fortuitous event po attorney because the school has a permit and there is no record in the city that the school has kanang wala na tarong ang ilahang mga roof. And there is no report also attorney that the school is under or what we call that a renovation or daan attorney the roof.
Sige, do you agree, Ma'am Annie, that the
Yes.
school
Yes po, attorney.
kaso fortuito?
Yes po, attorney.
So, what was the proximate cause of the injury suffered by the Dimaano in this case?
It was because of the typhoon Saling po, attorney. The Dimaano family suffered they suffered the damages po due to typhoon Saling, wherein the roof of the school building naato silang balay po. So due to typhoon po, attorney.
It's purely accident, no? It was
Accident po.
Okay, so the proximate cause of the injury suffered by the Dimaano said the court was purely typhoon Saling. It could not be blamed to the school, no? Their roofing, no, was ripped off, no, portion of the roof was ripped off, no? And heating the house of the Dimano. See, that is a case of Southeastern College versus Court of Appeal. How about Philcom Satellite versus Globe? Si Sir Ismael. What was the relationship between Philcomsat and Globe?
So, in the case of Philippine Communications Satellite versus Globe, so the relationship between Philcomsat and Globe, there is a contract between Philcomsat and Globe Telecom to establish and operate an IBS standard B Earth station at Subic Naval Base. So it was a contract to a 5-year agreement provided that Globe would pay monthly rentals to Philcomsat for lease circuit minimum to P1 lines, even if service was discontinued, unless Philcomsat resolved or used the facility at any.
Sige, so there was a contractual gap lang relationship na Philcom Satellite versus Globe, no? What happened in this case, no? What was the contention of Philcom Satellite, no? Why it should not be held liable for better question, is Globe, no, legally obliged to, so after terminating the agreement, prematurely terminating the agreement, is it still legally obliged to pay the remaining terms of the agreement? Sir, can Globe be compelled to pay the remaining terms of the agreement?
No, attorney.
Sige, what was the rationale?
Because under Article 1174, force majeure includes events which could not be foreseen or which, though foreseen, were inevitable. So the agreement enumerated events beyond the parties' control, government acts in emergencies, war, and like, which is consistent with this definition. So in this case, the U.S. withdraw their basis agreement to the Philippines attorney and their base agreement to the Philippines. So after the termination of the contract, it also terminated the contract of Globe to Philcomsat because Globe did not foresee that event, attorney.
So you're saying that it's a fortuitous event, no? That it was the non-ratification by the Senate, no, of the RPU's U.S. military bases agreement, no, which was the cause of the failure, no, of Globe to pay for the remaining rentals. So said the court na it was that the said circumstance, no, constitutes force majeure, no, fortuitous event, no, as defined even in their contractual agreement, no, in their contract. So it is a valid defense, no, for Globe not to pay the remaining rental agreement despite supposed breach committed by Globe, no? Sige, how about the Phil Estate Properties Incorporated versus Go? Si Sir Villanueva. Christopher.
In the
Question.
case of
Was the Asian financial crisis considered a fortuitous event?
no, attorney.
Okay. Sige. So, what was the relationship of Phil Estate here and Go?
Petitioner Real Estate Properties Corporation or the estate entered into a contract to sell a condominium unit to spouses go attorney.
So to cut the story short, no, Phil Estate was unable to develop, or it failed to deliver the project or the unit to the spouse, to the go, correct?
Yes, attorney.
And what was the defense of, you know? What was the
The
defense
defense of
Phil
sorry,
Estate?
attorney. The defense of real estate attorney is due to the Asian financial crisis, which attributed to the delay in the construction.
Okay. Okay. So the court no did not did not believe
Yes, attorney.
did not appreciate the arguments of Phil Estate because of the Asian financial crisis is not a fortuitous event. No, said the court, as developers, as condominium project developers, they are supposed to be masters in projections on the commodities and currency movements, no, on business. Right. So from the time that you contracted the obligation, you according to the court, no, dapat i-consider na nimo in fixing the purchase price. Correct? So that is why if there is fluctuation or there is inflation, etc., extraordinary inflation or deflation, so your contract is unaffected. You have to deliver your contract, no, in accordance. No, you have to comply with your obligations in your contract, no, because said the court, no, it is the Asian financial crisis, no, was not unforeseen. No, it's not, or it is not totally unavoidable, no. Okay, the effect of that Asian financial crisis is not totally unavoidable because in the first place, as I said, gi-increasean din mo na ang contract price, no, so that it can cope up, no, with the Asian financial crisis. Sige, thank you so much, no. Sama na ko ni pag-brief. Okay, sige. So usurious transactions, no, shall be governed by special laws. No? The Central Bank of the Philippines, no, actually removed the ceiling, no, or parties can now free to stipulate, no, as to the interest rate, no, of a forbearance, for the forbearance of money or loan transactions, no, but it does not give authority to the creditor or mortgagee, that are the carte blanche authority, no, to raise the interest rate, the rate of the interest unilaterally, because even if they can fix it, they have they under the autonomy of contracts, no, parties are free to stipulate. Although they can do that, no, but still it is subject to the principle of mutuality of contracts, no, that any changes in the agreement must be mutually agreed upon, must be based on reciprocity, no, so that if you violate that rule, no, the court struck agreements on interest rate for being unconscionable, no, or iniquitous, and for being violative of that reciprocity, no, between the parties in entering into a contract. Okay? If there is no stipulation as to, take note, you cannot collect interest if there is no written contract or written agreement. No, so dili pwede nga, okay, sablay, paano mo, 100,000, 20% interest, verbal lang, dili pwede. No, there must be a written instrument or a contract for the payment of interest. If there is none, no, you can only claim for the legal interest, no, and you can only do that from the time there was or there is default, no, and when is there default gani, pero sa gani na default, Sige daw, kano sa ganina default class?
After demand is made, attorney.
After demand, either extrajudicial or judicial. So take note that that is the only time na you can collect for interest. No, before July 1 to 2013, the legal interest was 12%. Thereafter, it's 6%. No, legal interest per annum. No, but again, how do you harmonize that to the principle we just mentioned, no, or that there is no more ceiling, no, in the fixing of the interest rate. No, what happens in okay. Sige, no, the parties, they can actually agree to an interest rate of 20% per week, etc. Sa unsa pa na, no? However, what will happen, no, if mo mag-file og kaso ang debtor in court, no? So the court will say na your agreement as to the interest is void. So what will happen? You cannot anymore collect. No, so balik lang ka og legal interest, which is 6% per annum. But jurisprudence tells us na you can collect up to 24. What is the how about banks? How much is the annual interest for loans in banks? Who works in banks here? Kinsa nagtrabaho bangko? Ha, wala? See, how about si Ma'am Labor, si Christine? How much is the interest rate for loans in banks?
Attorney, I'm not sure po kung how much attorney, pero yung alam ko lang po is yung legal interest rate at 12%. Hindi ako sure.
Sige. Kinsay naka-loan sa bank dere? Or transactions with the bank, no? Sige, si Arcile or sa to
Arcile Abiliare po, attorney.
what is the interest rate of interest for
As of now, good evening, attorney. As of known, which is my anti-mortgage this, her property is, the annual interest is 6% to 7%, attorney.
But how about, di ba, did you, or wala jud man, you have no idea. But other financing mga services, tawanan or cooperatives, they can, they can impose interest rate up to 24% or even up to 26% per annum. No, that is allowed, no, in jurisprudence. Aside from that, aside from the interest rate, you can also impose additional penalty. Now take note, penalty and interest, they are different. They are not the same. No, interest rate is your income for letting someone borrow money from you. So that is the interest, your income, no, the interest. Penalty, on the other hand, that is different from interest. So if you fail to pay on time, no, you will be liable to pay the penalty in addition to the interest. So that's how you circumvent, no, that law, no, na you cannot how you circumvent that kind of 6% legal interest, no. You can charge as much as 24% per annum, no, and then additional penalty, say for another 24%, you can do that. Let's see the cases now, if it's allowed in the cases now. Sulangon versus Salazar. Okay, what happened in this case? Do you have a volunteer? Sa'yo pa man, no? As wala may volunteer? Sige, I'll call someone. Okay. So we have a volunteer, Sir Levy Elmerson Doyo.
Good evening, attorney.
For a while, sir, pagkitaon sa ako yung mga index. Did you submit your index?
Yes,
card?
attorney, I believe so.
Sige, for a while. Okay. Sige. Levi.
Levi, attorney.
Levi, okay. Sige, you proceed, no? What was the relationship here of between Solangon and Salazar?
They had a conflict, attorney. Spouses Danilo and Ursula Solangon owned a parcel of land in Santa Maria, Bulacan. Over time, they entered into loan transactions with Jose Avelino Salazar, and they repeatedly used the same property as collateral through real estate mortgages. First, on August 22, 1986, the spouses executed a real estate mortgage in Salazar's favor to secure a loan of 60,000 payable in 4 months with interest at 6% per month. Later, on May 27, 1987, they executed a second mortgage over the same property.
Yeah, there were several mortgages, correct?
Yes, attorney.
No. And did you observe, no? Ang unang mortgage, 6%
Per month po, attorney.
per month, no? So how much is that per annum? 60, 70,
72%.
72% per annum. Okay, so and there are other
Other loans po, attorney. Second and third loans po.
okay, so there were 3 loans. Now how much is so 72% per annum ang permiro ikaduha ikatulo.
I think it's the same po, attorney.
Okay. So was it was the agreement on interest rate valid? So,
No, attorney, it's
Levi?
it's usurious. What does that, no?
Usurious.
Yeah, usurious
Okay.
pattern. It's excessively high.
Sige. So what happened after the court declared that your agreement on the interest rate is usurious, iniquitous, and unconscionable? What will happen to the loan transaction? Will it be extinguished?
Will it be extinguished? No, attorney.
So what is the effect of that finding that the interest rate was usurious? How will it affect the obligation of Salazar or the debtor in this case, whoever that is, Salongon or Salazar? How will it affect Sir Levi?
Attorney, the appellants were denied of their appeal, attorney.
And then, sige, the appellants were denied of theirs. And how do you translate that to our discussion?
Because the trial court did not believe the spouses' version, they found their claim improbable since both spouses signed the mortgage documents and promissory note and dismissed the complaint. The Court of Appeals affirmed.
Okay, so Sir Levi, ingon ka nga the interest rate was usurious.
Yes, po, attorney.
Diba? So it is void. The agreement, as to the interest is void, correct? So
Yes,
what's the
po.
effect, to their contract? Mawala ba ang contract of loan? Sir Levi, mawala ba o dili?
No, attorney.
Okay, what is the effect therefore? Are the debtors, are they compelled to pay the 72% per annum interest?
There will be applied a special law, attorney. They would have to reduce it to 12%, attorney.
Ano man, kung ano this is before, July 1, 2013? Or simply you apply the legal interest, no?
Yes, po, attorney.
So I mentioned earlier, na if the court will struck your agreement as to the interest as void, so therefore it's as if there is no agreement as to the interest. What happens? you are only entitled to legal interest, either 12% or 6%, depending on the time the decision became final, no, non-executory. So after July 1, 2013, the legal interest is only 6%. So nato no, even the court in some cases no, 6% per annums on ang court na that is inequitous or unconscionable, which is contrary to morals, if not against the law. What more in this case, the 72% per annum. No? So in this case, yes, you're correct. You know, it was reduced to the legal interest of 12% because this was perhaps this was before July 1, 2013. So, may tabo ha, kung void ang inyong agreement as the interest, of course, dili mawala imong loan, imong utang. No, correct, unfair, no? The only declared void is the agreement as to the interest. So if there is no agreement, let's go back to the legal interest, which is 6 or 12%. So that is the case of remember that Sulangon versus Salazar, JR number 125944, June 29, 2001. So thank you, Sir Levi. Okay. Sige. This is one, the presumptions, no? Presumptive presumptions. So presumptions laid down under Article 1176, no? Which is paid first? Kung magbayad ka utang, which is paid first? The principal or the interest? Sino, Sir Levi? Kung magbayad ka utang.
I believe it's the principal attorney. Plus,
Okay, do you agree? Let's hear from Ms. Labor. Do you agree? Una ako nagbayad ang principal?
No po, attorney. Nauna po yung interest.
I think it's the I equals PRT attorney. The formula I equals PRT.
What do you mean by that? No, I'm not familiar with that.
The principal times the rate times the attorney times the time.
Skin, Elise? Is there such a formula?
Ano po, attorney? Nauna po yung interest. As far as I can remember po, before yung principal.
Sige. Sir Levi, if you are the creditor, ikaw nagpautang, will you allow your debtor to pay the principal first or the interest?
Actually, it's actually the interest pala, attorney.
Okay. So you pay the interest first, di ba? Okay. If you will pay because the principal amount was the basis in fixing the interest. So kung mo nang bayaran mo una ang principal, it would be unfair for the creditor. So nakunin mo ang interest. Now, 1176 first paragraph, if you receive payment for the principal without reservation as to the payment of the interest, now there is a presumption that the interest was already paid. The second paragraph, if you receive a later installment without making any reservation as to past unpaid installments, the presumption is that those past installments are already paid. Take note. But again, these are only disputable presumptions. Unlike conclusive presumptions that you are not allowed to provide proof to the contrary. Now, these are merely disputable presumptions. Take note, disputable, disputable presumption versus okay. Sige. 1177, this is actually a good article, no? This gives the creditor the remedy or the remedy available to him or her in case he cannot collect what is due him. No? What do you do if you're the creditor under 1177? Can you take over the property of your debtor, or can you confiscate his television, his refrigerator? Can you take possession of his house, or can you? What do you think? What are the remedies available to the creditor? Sige daw. under Article 1177. Okay, let's hear from sige na, Sir Uy Engelbert.
Attorney, unless if the on the contract na asay there's a collateral prior for borrowing the borrowing or loaning a certain amount, so that the borrower must have a collateral, and then that the lender could pursue or claim the said collateral on the contract if the borrower are not able to pay on the said contract, attorney.
What if, Sir Engelbert, what if there was no collateral? Do you do as creditor?
The only thing that the creditor could do is file a case for staffa, because he cannot grab a certain asset of the borrower if that wasn't been on the contract. So
As filing a criminal case for staff, ano, okay? Before you can do that, you have to prove that the fraud was used, no, in order for you to enter into a contract, in order for you to part with your money. No, but failure to pay a loan, certainly it's not staffa. Unless you can prove that.
okay.
Sige. So what do you do? Kunwari, walang, ano, no, the answer is in front of you, no, 1177. What do you do if wala collateral?
Exercise the rights to bring all the actions on the latter, the same purpose.
Sige, what do you think? Will you do, Sir Engelbert, if somebody will not, if your debtor will not pay their loan obligations?
I think, attorney, on Article 1177, they could exercise their rights by or maybe satisfy their claims on the said amount of the borrowers equivalent to the amount of that was borrowed from the debtor, attorney.
At least how many remedies mentioned in, in Article 1177, take note of at least 4 remedies. Okay, but of course, given 3 remedies. Number 1, of course, what will you do? You have to demand payment. Number 1. That is what you do. Demand payment. If they cannot pay, what do you do next? You can, under Article 1177, you can pursue the properties under the name of your creditor, or in the possession of your, in the name of the debtor, or in the possession of your debtor. No? Okay, you can, okay.
Attorney, sorry to interrupt. So the debtor can lien the property of the borrower if the said amount wasn't been paid, right, attorney?
Can
Lien. Pwede nila malien ang property sa borrower.
So when you say lien, it's actually a proceeding na ay kaso, no? And then you will annotate your lien or claim over the property. So kung ay titulo, ipa-annotate nimo kini siya na utang sa kuha. So you can do that, no? Or sue properties in possession of the debtor, no? Yeah. Para so that if there's a case, no, or encumbrance or lien, no, pwede ka mo to sa ROD, no, para magpa-annotate kasi mo ang claim. That is one way. Pursue the properties in possession of the debtor. But that is merely for your protection, and you cannot collect it unless you do something. So one, you can file a case in court, no, for attachment maybe, no, or for the collection of debt, no. So and at first instance, you will file for attachment, no, para kuha na mga properties. You can go against all the properties in possession of the debtor or those registered under her name, no, or his name. Next, what do you do next? Kung tayo, what if walay property? Sir, Engelbert, wala dyan property, what do you do next?
I think the debtor can sign a promissory note. The best thing he can do is the borrower can he can let the borrower sign a promissory note
Balik na
to
po ta.
pay.
Balik na po ta, Sir Engelbert. Ato na po ta, ngita na po ka, man mo. Balik ka po ta diri, walay property. What do you do next? Under na sa 1177. Naghapon. Next is, the creditor may exercise all the rights and bring all the actions that it has over, say, for example, third persons. Now, you call that action subrogatoria. Take note, take note. Your next remedy, action subrogatoria. Pagtang na sa inyo, sa inyong caudal. What happens? So, let's say, for example, ang imuhang debtor, Sir Engelbert, is si Sir Levi. Just for the sake of example, Sir Levi, Okay, now, debtor, now, si Sir Levi, dili na siya kabayad, wala siya property. Pero you found out later on, Sir Engelbert, na si Ma'am Blanche na siya utang kay Sir Levi in the amount of 1 million pesos. So what do you do? No, ikaw na karon, you step into the shoes of Sir Levi, you become the creditor of Ma'am Blanche. No, you may bring all actions that are available to your debtor. In our example, Sir Levi, you can file a case against Ma'am Blanche for you to be able to collect your credit. No? Or say, for example, si Sir Adrian po, na siya loan with Sir Levi and there's a collateral na rem. Okay? You can proceed against that collateral, Sir Engelbert, because again, you can or you may exercise all the rights and actions that your debtor can bring against third person. That is what you call action subrogatoria. What if wala joy property, walay dili creditor ang imong debtor? What happens next? Do you surrender already? No, 1177 provides us final remedy of action poliana. Take note, action poliana. But it is a remedy of last resort. If you want to file a case for action poliana in court, you have to establish na niagi ka you have availed of all the remedies mentioned under 1177. You have exact payment, demanded payment. You have pursued the properties in possession of the debtor. You have exercised action subrogatoria and still you fail to collect your credit. So now you file for action poliana. And what is that? No, suppose you found out that in the same example, Sir Engelbert, suppose you found out na during mga 2 years ago, in order to escape, or just recently you found ano pa si Sir Engelbert? Nawa man.
Yes, attorney. Napa.
Okay. No, suppose you found out na Sir Levi nasa property pero iyang gipang donate to, say for example, to his neighbors or to his wife or to his relative, or to his parents. Sir Levi did that in order to escape payment. Wala na siya property mabira. So what do? You file for the rescission of that donation. Action poliana. Action poliana. Okay? You can impugn acts which the debtor may have done in order to defraud you. Take note of what I mentioned, that Sir Levi donated the property in order to escape your collection efforts. So you can actually cancel those donation executed by your debtor in favor of a third person. So take note of the successive remedies. You cannot go to court and file immediately for nakita nimo ay may property na siya na gidonate. You want to cancel that because you want that property, you cannot do that. You have to follow the procedures. No? Because again, this action Pollyanna is a remedy of last resort. Take note, before you can bring the action, you must have taken successively the aforementioned measures under Article 1177. Are we clear, class? Do you have any questions regarding
Thank you,
1177?
Attorney.
Sige. So this is actually a good a good article 1177. So we have a question from somebody raised their hand. Kinsa man ito? Si Ma'am Sophia, yes, Monique Manla.
Good evening, attorney. I was gonna ask attorney if action directa is also considered as a remedy of creditors to satisfy their claims against the debtor.
Okay, and what is that action directa?
Uh, it says here that it is the right of the lessor to go directly against the sublessee for unpaid rents of the lessee.
That is not it's a lease agreement man. It's different. So we are talking here.
Thank you, attorney.
If it is if it can be, you suppose you have it's a lease contract, then your lessee, yes, lessee, cannot pay, so you go against the sublessee. No? So, but I don't think that you can go as much as going after the or action you can action subrogatoria. That is actually action subrogatoria, Sophia. No? But because it's a contract of lease, it's called action directa.
Yes, attorney. Yes, attorney.
To go against third persons. No? That is the same as action subrogatoria. You step into the shoes of your lessor and then you collect from your debtors. In your case, you collect from your sublessors. Diba? Sige. Action directa, di tawag na, no? Okay? Good to know, no? Action directa. Okay. Other questions?
Attorney, good evening.
Yes. Sige, I think...
For confirmation, attorney.
Kaya. Si Sir, kisa man Phil, si Kwan, si Sir,
Salinas po.
Yes. Question, Sir Salinas.
Confirmation lang niya, attorney, tama pa po akong understanding ang 1177, dili siya absolute when it comes to kung si Levy, ganyan ang example, nagbaligya siya og property tapos ang katong obligasyon niya kay Sir Engelbert, dili ka force si Engelbert sa katong sales kabag ulang nahitabo, no?
What do you mean? Dili ka
institute of action si Sir Engelbert
Ang
sa
kulyar?
sa property nga bag ulang nahalin, given the fact nga napa siya obligasyon kang Sir Engelbert nagbaligya siya bag ulang.
So, your question is, Sir, sa may question mo, dili ka,
Ang 1177, dili saklaw nga ang katong pagbaligya sa sale nga bag-o lang nahitabo when it comes nga naa pa may obligasyon unta nga bayron nun si Sir Libby sa example kang Sir Engelbert niya. Nalaman ni Sir Engelbert, ay bag-o lang nagbaligya siya sa iyahang property. Pwede ba to, murag dili ba po na to nino, dili saklaw sa 1177?
you can go back to 1177, you go back to exact payment and then properties in possession of the debtor. So kung nasa bagong baligya, so nasa property na po, money specifically to pay for your for your debt. But what is contemplated here in 1177 kining mga ganing action Pollyanna, usually what is contemplated are those mga gratuitous contracts, no? klaro gali kay nimo ayaran ning gidispose para lang wala say property to pay you. Or say for example, this is a 1 million peso house and lot and you only sold it for 100,000 just so you can escape payment of your debts. So the court will actually treat the remaining 900,000 pesos as donation, as gratuitous, and the creditor can actually file for action poliana, cancel, rescind that contract, no, because it was made in order to defraud Sir Engelbert in our example. Okay? So, it's all circumstantial, no? Kita nimo nga, maligya naman siya ganun, property, pero, and then you can go back to, demand payment, and then pursue properties, bank deposits even, of your debtor, no, to, or to satisfy your claim. Okay? Other questions? So, Mark Ludes.
Pero dili ba maulag na protected ang other person kung receive sa property sa...
What if, another question, a good question actually, no, I hope na di na nyo na magkano, okay, it will be discussed in your but a good question. It will depend on whether the third person was in good faith or in bad faith. Now, if the third person was in bad faith, of course, in our example, Sir Engelbert can actually recover the property from the third person. But if not, or let's say for example, if the third party was in good faith, so therefore, your only remedy is against your debtor who donated the property in bad faith. No? Okay? Depends on whether there was good faith or bad faith on the part of the third person. Especially if, say it's not a donation, it's a sale for a valuable consideration, and in good faith, you are protected. The third person is protected. No, take note. Okay, other questions?
Even if natin ay panlap attorney, even if gratuitous on its face attorney, gratuitous na ang transfer, protected yapon tong third person na in good faith.
There's a document, no, a donation na no? What do you mean by that? Its face. So if it is made in order to defraud your creditor, it may be cancelled. So you have to prove that in court. No, sige, that it was fraudulent, no, that the donation was fraudulent. See, other questions? Okay, before we proceed now. So 1178, no, rights, all rights may be waived. Article 6, 1178, subject to the laws, all rights acquired by virtue of an obligation, no, they are transmissible. The transmissibility of rights. Of course, when there is a law providing for the contrary, or when the right is purely personal. No, let's say for example, the right to receive support, no, the right of a spouse, marital obligation, no, they are purely personal, they cannot be transferred to the neighbors. No, the right to support, no, etc. Unless they are purely personal. Nag-ngisi si Ma'am Persephone, no, Azanabe. Okay. Any other, and that ends, the first part of our ang PowerPoint. Next, we will discuss the different types of obligations. Do you have any questions? Sige, kanin, next week, no, face-to-face ta. No, so expect for a quiz. And I'll return also your previous paper, no, sa inyong quiz para ma-train mo, no. Ibalik na ko sa inyo para ma-inspire mo. Inspire mo sa inyong result sa exam. Pero, sige. See you next week, except for, si Mark, do you have any question, Mark?
Nalibol attorney if sa usurious transaction attorney ba, pinsa na ang ayon sa na ang mag-govern attorney ang civil code or special law. Kalimot ko sa doctrine attorney. Special
Usurious
law,
transactions,
govern-
no, usury law, again, na may issuance from the central bank, no, lifting that ceiling, no. So, pwede na ka mag-fix of interest rate. Pero however, jurisprudence, no, would essentially govern that, that transaction, whether this is usurious or not. No, it's the court who will decide, no, which will decide your interest rate is inequitous, no, uncontrollable, therefore void. Kaya wala na may usury law, no, wala na may usurious transactions. So they are only wala na siya sa by the central bank. There was a issuance, no, siya specific central bank or wala. Okay, the monetary circular number, no, it's not, I don't know, hindi ko sure sa exact, siya. CB circular number 905, no? So the usury law is actually rendered illusory. No, wala na yung usury law because of that issuance, CB circular. So although, but, di ba, although wala usury law, pero the court may step in, and struck as usurious your transaction because it's against public policy, against public morals, no? To take note of that. Sige, some other questions? Sige, next week we will discuss the different kinds of obligations. No, so you read in advance, para we can have a meaningful discussion. Wala na questions? And also you prepare, okay, you know already 1/2 sheet of crosswise yellow paper for your quiz next week. Okay, I believe na nakasubmit na tanan no? Flashcard? Yes? No, nakasubmit na? Sige.
Attorney, ako online lang ko. Attorney na ako kagayon di oro.
Yeah. You and who else? And except si Sir Engelbert, how about si Ma'am Isabella?
Earlier na po ko sa Tagum attorney.
You will be joining us face to face,
Yes, attorney.
Who else? Si Andrea.
Yes po, attorney, sa Mati po, attorney Mati City po.
So diha ka wala kay nag-ano Tagum?
Ano po, attorney, pag exam po, naga-face-to-face ko exam, attorney.
Nausama mo, wala kay face-to-face na klase?
Wala po, attorney.
Sige, I will expect. How about you, Sir Engelbert, face-to-face pagka-exam lang?
Online ko attorney sa exam. Kaya usahay mo, out of the country ko attorney ba?
Ba? Pero did you make arrangement already with the, with the...
Yes po, registered.
Okay, about that. Sige, I'll expect so much from you, Kaya naka-online na mo. Especially Sir Engelbert. Pero sa Mamanda will join us face-to-face, Sige, sige. I'll have to consult first with the management, no? With regard to, Pero if you have already disclosed that upon your enrollment already, and you are allowed to enroll, Pero unsa nimo sir, first semester di man yun, or second?
Second semester, attorney.
You were already under Attorney Judy and Attorney Buhol and among others. Attorney, kinsa poli ganinyo, si Attorney Political Law, si Attorney ano ba?
Attorney Priscil Bongkawil, Attorney Alphonse Tiwan. We have Attorney Villarico now.
Sige. So, gi-allow man kanila Sir Engelbert, no?
Yes po, attorney.
Gi-allow kay kanila na dinayante ka i-allow, no? So, si ko na lang po, si Andrea, ayun, how about the others who can not join us face-to-face next week? Wala na ha, so you will be there no next week. Sige. I think that's all. Do you have any?
Attorney,
Yes.
sa ako po nga case, attorney, napoy time nga dili ko ka face to face, attorney. Anda ako magod ko, attorney, di oro ko.
Sige, usawa na to. Sige, tanaw na to. Ano, please. Masa, tanaw na ko na inyong quiz. How are we going to do about it, no? Again, my intention for your quiz is actually to assess your writing skills. So if you have the basic foundation for passing or for taking the bar exam, kung pwede naman mo, no? And I can only truly assess you guys if you do it under pressure and nakita dito not online na etc. Because it's but anyways, it's up to you guys. Sige. Other concerns. So si Sir Sir, so you will be online next week, sir? Salinas? As much as
Depende po,
possible.
baka anak ko attorney kayo sahay ang weather po na mo ang nature sa akong trabaho na po sahay nga nami evaluation ba niya di na ako makayag travel sa Tagum kay almost 1.5 hour man po ng travel sa attorney.
Sige. What else? Who else? Isa pa yung na-concern. Sige, wala na ilain na. Kamuntahan mga attendance sa klase o face-to-face. Sige. I'll see you next week, class. Before we end, Sir Salinas, lead us to closing prayer, please.
Our Heavenly Father, thank you for the gift of life, thank you for everything, thank you for the wisdom. May I ask your Holy Spirit to guide us in this journey as being to become a lawyer. This we ask through Christ our Lord. Amen.
And Father, and Son, and Spirit. Sige, I'll see you next week. Kumanaman ay ma'am, libre, no, Ma'am Michelle. Pasensya sa screenshot sa atong GC. Thank you so much. You can now leave the Zoom classroom.
Thank you, attorney.
Thank you.